So can the current legal framework sufficiently deal with the dilemma of ethics in digital lawmaking? And we have also touched upon this, but maybe now it's time to discuss it a bit more thoroughly and properly. Jan, would you like to begin with this, to answering this question?
Yes, great, thank you. So thank you for having me as well. It's a very interesting, some interesting thoughts have been spoken already. Now, with this question, of course, ethics and law, well, the first thing that I would like to say is that whether we can solve this dilemma, of course, depends upon which ethical framework you start from. I will not go into detail. I'm a legal scholar, I'm not an ethicist, so I'm quite sure that Professor Hildebrandt may have other way better visions on this one. But depending upon your ethical framework that you take, and whether you look at the consequences of something or whether you look at the actions as a starting point, this will of course have an impact on the legal decisions, the legal framework that may apply. For example, I'm doing a lot of research on autonomous vehicles and self-driving cars. Well, there you have this trolley problem, which says that what should the car do when being confronted with having to make a choice, killing 3 people or killing one person, for example. Well, then depending upon the ethical approach you take, you will have different outcomes. For example, if you would look at the utilitarian approach, which looks at the consequences, well, then you will program the car by saving most lives as possible. So this is an approach. If you would, by contrast, start from a more value perspective, looking at actions, well, then of course you will look at the actions that a car has to take, and you will actually program the car to not take specific actions to kill someone. So this is the first thing, that depending upon the ethical framework that you take, you may have different approaches and may have different solutions. A second point that I would like to make is that when we take into account the digital and legal aspects, we need to ensure, that is what we call the by design approach, that all these societal, legal, and ethical considerations are already taken into account when developing AI, when developing technology. This is the by design, ethics by design, or privacy by design, for example. So we have to take this into account as soon as possible. How can you do this? Well, multidisciplinary teams, interaction, responsible research and innovation. So there are certain processes in the way before the law is actually applied, and this is what Laurence already mentioned as well, that we have to look at this pre-situation. A third element is that when we program, and this has already been mentioned here, code as law, and again, if you take out autonomous vehicles, you can very well program objective requirements in the legal framework. Giving priority to the right, stopping at a red light. Well, these are quite easy objective elements that you can program. However, the traffic codes are full of subjective elements. For example, you need to adapt your speed to the situation. Well, this requires a subjective assessment. You have to be twice careful when coming on a roundabout. These are provisions in the Belgian Highway Code, and I assume in many other codes as well. But these require some subjective considerations, which are difficult, I think, to plan, to program into machines. And then a final thought, 30 seconds, with the interaction between law and ethics. Well, and it's related already to a question that has been asked in the chat. A lot of ethical considerations, a lot of ethical requirements are already translated into the legal framework. For example, if you look at the trustworthy AI and the ethical guidelines that were issued by the HLEC, high-level group, the transparency, privacy, well, these are elements that you can already find into the law. Not all of them. I reckon that maybe human oversight might be more specifically provided in the law, but we should be sure that ethics and law interact, and these ethical requirements are sometimes already part of legal frameworks. And this is what my points for debate, maybe.
Great, thank you. Also good to hear about some points that we also talk about in our units, for instance, the digital by default. Mireille, would you like to take the floor?
Yes, thank you very much. So it's very interesting. We are talking about digital ready law making, but the question now has turned to digital lawmaking, and that's a very important distinction. So are we talking about replacing text-driven legislation, because we take for granted that law and legislation is about text, that it is articulated in text, that has a whole range of consequences, also in the sense that the citizens, the users of the law, and I totally agree with Laurence that maybe user is not the right term here, that citizens who are subject to the law can understand the law and can contest it, which once again, I'm coming back to the rule of law, is very important. If we're moving from text-driven law to something else, which may be code-driven, code as law, so translating a text into computer code, then we're taking a further step from digital ready, because digital ready means you're going to develop the text in such a way that it is easier to work with, to interact with from the digital perspective. And I think that's a very different thing. But I also like the fact that we are already raising that question, because we all know they're going to flow into each other. My perspective would be is that we should not do digital lawmaking. The law should not be, the law that is in force, that is applicable, should not be computer code, for a simple reason that people will not understand it, and that it is disambiguated. That takes away the core of the rule of law. So the text should remain what is applicable. And if we are going to somehow decomplexify, disambiguate it into digital, into code, then the authority, what is in force, should be nevertheless the text. So I believe we should not do digital lawmaking, and I also think it doesn't exist. It would go against the grain of what is law. Now, to the extent that we're going to use these type of digital technologies in the process of legislation, and I'm not saying that that would be a bad thing. That, of course, depends on how you do it. Then I want to look at the current legal framework and take one step ahead and look at the proposed AI legislation. And when you look at Title 3, Chapter 2, so that is the requirements that apply to high-risk systems. And those requirements include risk management system, quality management system, data governance, when you're talking about training of machine learning on data. And I think that's going to be highly relevant here, because you are going to open up the text of the law for analytics on top of it, with all sorts of predictive tools, legal search tools, which will create an entire political economy of who has the best legal search stuff, etc. This is, of course, already happening. That it is going to be extremely important to make sure that these types of technologies are qualified as high risk, and that all these quality assurance requirements that are in Chapter 2, Title 3 that I just called out, one of which is also human oversight, and I would advise anybody to read Article 14 carefully, to bring that under this regime. And I would say that's much more important than making us dependent on the ethical inclinations of whoever is developing this stuff. Thank you.
Thank you. And Jelle, perhaps would you have anything to add to the existing discussion?
Maybe, yes. I'm no scholar or have any legal background, but the discussion so far, I noted two things. Maybe one, I'd like to go back to the multiple reference to code as law. If I would say this to one of our companies, they would say, yes, please, I would want to have that. Please ensure that we can have code as law. Why? Because from a company point of view, one of the most difficult or the biggest issue is implementation, be it of a current legal framework. The GDPR is, I think, a very good example there, and I expect that for the AI regulation, we will probably have similar difficulties. But I note as well, indeed, that the problem which was not solved, if we would have this type of implementation, is who interprets it. So I just note maybe there would be the future some sort of code court who could maybe assist there, just putting it out there. And then Mireille said it would be difficult indeed to make law fully into code. But what I would say there is already in European legislation, we rely a lot on harmonized standards, for example. So we have the text which is giving the general requirements, and then harmonized standards are introduced in a way to help implement this regulation. Why should we not go to something like harmonized code for helping us implement regulation? Just two thoughts which I want to put out there. On the specific question, can the current legal framework sufficiently deal? From my point of view, why do we have law? To ensure that our ethical values are in a way fixed in a certain into a legal text. But from my point of view as well, ethical values are not something which is static. They are evolving in a way. And I think law is there lagging behind a little bit. So meaning there will, from my point of view, always be a certain intersection where we are advancing our let's say our ethics, and law cannot maybe keep up. Is this a problem? Not necessarily from my point of view, but we have to consider what are the special the cases which do not fall under a legal framework but fall under the ethical framework. Which risks do they bring? Which potential harm do they bring to society or to people in general? This is something to consider. So can the legal framework sufficiently deal? Mostly yes, in some cases no, but it's very important to know what are these cases and how can we ensure that there is no, let's say, very bad influence on us as people or society.